Welcome to The Explainer. I'm really glad you're joining us today because we are diving into a truly fascinating and honestly a highly complex legal controversy. Today we're going to unpack the anatomy of a criminal conviction in the digital age. We'll look at how legal boundaries are drawn around the stuff we share online every single day and how the justice system measures the impact of a simple click. We're keeping things strict here, looking entirely through the lens of legal statutes, procedural laws, and the fundamental mechanics of criminal justice based on our source material. It's a fascinating case study on how the law interprets our digital lives. To really grasp the gravity of this legal analysis, we have to start right at the core tension of the case. Just imagine this for a second. A highly educated man, Dr. Chen, has his home raided by the police. The result? A prison sentence. And the core action that literally led to this? A series of one-click retweets. What makes this so incredibly striking is the stark contrast, right? You have this seemingly minor action, passively sharing content on an account with fewer than 100 followers, pitted against the absolute severity of criminal imprisonment. Okay, let's dive into this. The official legal charge leveled against Dr. Chen was picking quarrels and provoking trouble. Now, in the context of the internet, this specific charge is often applied to spreading false information that supposedly disrupts social order. Our sources today take a deep, very objective dive into the actual legal mechanics of this exact charge, specifically as it was applied to Dr. Chen's retweets. We're going to look at exactly how the prosecution built their case and how the defense systematically dismantled it using the very letter of the law. Here's our roadmap for the explainer. First, the case of Dr. Chen. Second, defining false information. Third, the question of intent. Fourth, measuring public harm. Fifth, the burden of proof. And finally, legal boundaries and takeaways. Let's start with Section 1, the case of Dr. Chen. So looking at the timeline, this spans from July 2019 to April 2022. During this period, he used a virtual private network and sporadically retweeted posts on a foreign chat app. The result of that activity was a 1 year and 8-month prison sentence. He appealed, but the sentence was upheld without a public trial. Now, from a strictly legal standpoint, the absolute crucial detail here is the evidence. You see, the evidence wasn't some complex conspiracy. It was just a digital collection of his online retweets. And the vast majority of these weren't even his original content. They were simply things he had shared from other users, which actually included official media and foreign embassy accounts. To secure a conviction for picking quarrels and provoking trouble via the internet, the law, specifically the interpretations laid out by the Supreme People's Court and Procuratorate, is actually incredibly strict. The prosecution has to definitively prove 3 distinct pillars. First, the information must be fabricated, false facts. Second, there has to be intent, meaning the person must subjectively know the information is false, but go ahead and spread it anyway. And third, the action must cause a serious disruption of public order. So this 3-part test is essentially our rubric for the rest of this explainer. And legally speaking, if even one of these fails, the conviction simply cannot stand. Moving on to Section 2, defining false information. Now, what's really interesting about this slide is how Dr. Chen's defense brilliantly categorized his retweets from prison. They put them into 4 distinct buckets. You have art, like political cartoons, emotion, like expressions of grief, opinion, like theoretical analysis, and finally, objective facts, like historical data. Well, in legal theory, only that 4th category, facts, is actually falsifiable. I mean, you can't fact-check human grief, right? And you certainly can't put a cartoon on trial for being false. So basically, 75% of the evidence used against him legally cannot even be subjected to a true or false test. It's a fundamental mismatch of categories. But here is where the massive legal clash occurs. The prosecution took a very sweeping approach. They took years of his sporadic retweets, the art, the emotions, the opinions, and the data, and they kind of just packaged them all together under this one umbrella term of rumors. Our legal analysis of the source material shows that this approach directly conflicts with the strict boundaries of criminal law. The law very clearly separates value judgments from factual statements. So by failing to filter out the subjective content, the prosecution's approach completely bypassed the fundamental requirement to prove that specific, objective facts were actually fabricated. That brings us to Section 3, the question of intent. Okay, so even if a retweet does contain a false fact, how on earth do you prove the citizen knew it was a lie? Well, the court used an argument called objective imputation. Basically, they claimed that because Dr. Chen has a PhD, he has a high ability to distinguish right from wrong, and therefore he must have known the posts were rumors. But legal analysts point out a massive flaw in this logic. It's a presumption of guilt based entirely on identity, not actual evidence. In modern digital law, the state simply cannot transfer its massive burden of professional fact-checking onto the shoulders of ordinary citizens. If the state hasn't debunked an online post, a citizen cannot be legally presumed to know it's a lie just because they have a college degree.
The law is incredibly clear on this point. It demands actual, concrete evidence proving the actor knew the information was false. Like, did they receive a formal warning? Did they actually participate in fabricating it? You really have to ask yourself, does a high level of education automatically imply a criminal intent to deceive? Under strict legal scrutiny, equating someone's intellectual capacity with criminal malice is an expansion of the law that totally bypasses the need for actual hard proof.
Now, let's look at Section 4, Measuring Public Harm.
Remember, the law doesn't just punish the sharing of false information, it specifically punishes the severe disruption that supposedly follows. So, I want to pose this question directly to you. Based on the strict legal requirement that the act must cause a serious disruption of public order, what was the actual physical consequence of these retweets? The answer, according to the case files analyzed in our sources, is zero. Literally zero evidence of riots, zero evidence of public panic, zero evidence of offline disruption whatsoever. No blocked traffic, nothing. The prosecution provided absolutely no quantifiable metrics to satisfy this absolutely crucial serious disruption requirement. Let's look at the actual data surrounding this complete lack of harm. Dr. Chen's account had fewer than 100 followers. His posts received minimal to zero engagement. Furthermore, and this is a really compelling point raised in his defense, many of the original posts he retweeted remain online to this very day. They are completely undeleted and have no official debunking attached to them. The legal relevance here is massive. The absolute lack of online reach, combined with the state's own inaction in removing the original content, heavily undermines the prosecution's claim that these retweets caused some severe, chaotic impact on society. Let's shift gears to Section 5, the burden of proof. And this brilliantly illustrates the core function of the criminal procedure law. It places the burden of proof squarely and entirely on the prosecution. They can't just make an accusation. They have to construct an unbroken chain of evidence. Step 1, objectively prove the information is a fabricated fact. Step 2, objectively prove the defendant knew it was false. And Step 3, objectively prove it resulted in offline chaos. In a court of law, the defendant does not have to prove their innocence. The state must prove their guilt on every single one of these steps. But when we compare the evidence to that standard, a pretty glaring gap emerges. The primary evidence submitted by the police was a general internal document literally titled Summary of Online Chat Platform. It was basically just a list of labeled content. The legal standard, however, requires rigorous, objective proof. We're talking third-party fact-checking to actually prove falsity, digital forensics to prove intent, quantifiable data to demonstrate offline consequences. Relying on a simple police summary document to shortcut these rigorous evidentiary steps is highlighted in our sources as a major procedural flaw. Finally, we arrive at Section 6, Legal Boundaries and Takeaways. So let's distill the core legal takeaways from all of this. First up, blurring the line between objective facts and subjective opinions risks turning the law into a pocket crime, which is essentially a vague tool that can capture almost any online expression. Second, the very architecture of the internet means citizens simply cannot bear the state's burden of fact-checking every single piece of information before they click share. It's just not feasible. And third, maintaining the integrity of the justice system means criminal convictions must always rely on concrete, verifiable evidence, never on logical presumptions just because of someone's education level. Maintaining these strict legal boundaries matters to absolutely everyone who uses a digital device. Which leaves us with this final, vital question to ponder. In our increasingly digital world, where exactly is the boundary between a state legitimately policing fabricated, dangerous facts and a state policing free expression and subjective thought? The case we've explored today shows just how delicate that balance really is, and how heavily we rely on the strict, objective letter of the law to maintain it. Thank you so much for joining me on this deep dive into the source material. I hope this explainer has sparked your curiosity and given you a much clearer lens through which to view the intersection of the law in our everyday digital lives.